This courtroom hearing starts tense, and quickly turns chaotic. Mr. Hicks, a self-proclaimed sovereign citizen, doesn't focus on the charges against him. Instead, he challenges the court's authority from the very beginning. He insists the judge has no jurisdiction and accuses the court of operating unlawfully. As Judge Perkins tries to move the hearing forward, Mr. Hicks repeatedly interrupts and refuses to follow basic court procedures. The judge calmly explains that jurisdiction is established under Michigan law and denies Mr. Hicks' motions to dismiss the case. He also warns him multiple times about being held in contempt for his constant interruptions. At one point, Mr. Hicks even suggests he could file federal charges against the judge. Despite the accusations, Judge Perkins remains composed and gives him two options: take a plea deal or proceed to a jury trial. Then comes the unexpected twist. The officers involved fail to appear in court, leading the judge to dismiss the case entirely. But even after the dismissal, Mr. Hicks boldly asks to collect court fees for defending himself, a request the judge immediately shuts down. What started as a simple hearing turned into a dramatic clash between courtroom authority and sovereign citizen ideology, and the ending surprised everyone.
Practice to practice law, and you've been practicing law over the bench.
You say I have been?
Would you like to litigate against me?
I'm not litigating anything against you.
Okay, you have been practicing law across the bench since we started this. And I'm challenging jurisdiction today.
Okay. What do you want to do, Mr. Hicks? You want a trial date, or you want the offer to send back?
I'm challenging jurisdiction.
Okay, put it in a motion.
I don't have to put it in the motion. I don't have to put it in the motion.
If I say you do, you do.
No, you don't have the right to do that. You don't have a Congress number. You don't have delegated authority to do that.
Okay. All right. Well,
I'm challenging jurisdiction.
Trial date. I'm denying. What is your motion? You're challenging my jurisdiction?
I'm challenging everybody's jurisdiction because you have none.
Okay, so
honor your oath of office, please. Honor your oath of office, okay?
Are we going to sit here and debate those positions?
It's not a debate. It's my constitutional right. It's my constitutional right.
You think so? Okay,
I know so. Are you violating my constitutional rights on how you deem them to be?
No, I'm not.
Okay.
I don't believe so.
And then please don't have me file for Title 18, 242.
Please do.
Okay, I have a transcript from all the other times I talked with you because you've been practicing across the bench for the longest.
Okay, so what are you going to do today, Mr. Hicks?
Challenge jurisdiction.
And how are you challenging that?
Because you have no jurisdiction. You have the burden of proof is on whoever assessed who's the assessor of jurisdiction.
I am in this case.
Okay.
And I deny that motion.
Why you deny the motion? Because you don't have.
So Mr. Hicks, you're a grown man. Let's have a few seconds. Wait a minute. Let's have a few second conversation, okay? Now let's get this straight. I'm running this show, okay? So if I'm gonna allow you to talk and say what you have to say, you're talking about challenging jurisdiction right now. That's what the discussion is. I say I have jurisdiction. The court rules say I have jurisdiction. The Constitution of the state of Michigan say I have jurisdiction. So I'm denying. No, don't talk while I'm talking. I'm denying your motion as far as you contesting my jurisdiction. Okay? So take your hood off, please. So other than that, what else do you want? How do you want to proceed now moving forward?
I motion to dismiss.
I'm denying that motion. Okay, let me ask you this. What basis are you denying the motion to dismiss?
Because no crime, a bill of attainder, no injured party. I told you all of this at the beginning, and you denied everything. You practice over the bench.
Okay, so now I'm going to give you two options.
As a matter of fact, hold on. Give me a minute. You even went through a 10 and 3 because you started threatening me. You remember that?
No, you were the one. Wait a minute. You were the one, Mr. Hicks, that said, "Oh, you can say all that while you're on the bench." All right. So now the jig is up with you. So I'm not letting you say any more about this. I'm denying your motions. Now I'm going to give you two options. The first option is you can either take the deal that's in the file, or we can. Okay. Don't talk while I'm talking.
I tell you what.
Don't talk while I'm talking.
A few minutes. I got your paperwork ready. You really want to
talk?
You really want to do this?
All right. Now I'm going to give you one more time to interrupt me. If you interrupt me again, I'm going to hold you in contempt of court. Okay. All right. So the other option is we set a jury trial, and we'll set the jury trial. I'll give you motion dates where you can have the dates and you can put all of your stuff in writing that you want before the court. And I'll make a date on that date. I'll make a date when I'll rule on those motions. So do you want the offer or do you want the jury trial date and the motions dates?
I thought that the trial was up to me, whether I have a bench trial or a jury trial. It's not up to you.
No, it's not up to you. I'm giving you, everybody has a right to a jury trial.
Absolutely.
And I'm going to allow you to exercise that jury trial right. I'm not going to sit here and entertain a bench trial for you. Let a jury of your peers determine your innocence or guilt.
Why would I do that?
How?
I have the right to either or. You're not the one.
No, you don't have a right. No, you don't have a right to either or.
Yes, I do. Of course, I do.
All right. I'm moving on.
All right, move on.
You didn't answer my question, so I'm moving on. And I'm going to put you out, or at least mute yourself. All right, let's do this, and let's go back on the record one more time with Mr. Hicks.
For the record, Your Honor, Diachiku Mason, City of Detroit, 43471. This is the date and time set for a final pretrial in this matter. Your Honor, I did subpoena my officers to be here today for the final pretrial, and I do not see them here today.
Remove your hat, please. No drinking, please. Treat this like you're in the courthouse. Remove your hat, please, Mr. Hicks. All right. What are we going to do? The officers were supposed to be here today. I'm only dealing with SP15, SP1442547, counts 1, 2, and 3, SP1442761, and SP500872. I'm only dealing with those matters. And the officers are not here. So we're going to make this easy. And now, what I don't appreciate is, I thought about that comment that you made that last time. Basically, you're almost like a little lightweight threat that you had toward me, saying that, oh, I'm only doing this. I'm only this way because I'm being protected by the bench. That's absolutely not. I'm the same way 24 hours a day. Okay? So let's get that straight. This robe has nothing to do with me as a man. All right, I'm going to dismiss the cases because no officer appear.
This courtroom hearing begins like many others, calm, routine, procedural. But within moments, it becomes clear that this is not going to be an ordinary day in court. Mr. Hicks, identifying himself as a sovereign citizen, steps forward with one mission: to challenge the authority of the court itself. Before any real discussion about the charges can even begin, he immediately questions jurisdiction. He insists that the court has no lawful power over him. According to him, the judge is operating outside the bounds of legitimate authority. He argues that the judge is practicing law from the bench, suggesting that the very act of presiding over the case is improper. Judge Perkins remains composed. He attempts to bring structure to the hearing, explaining that if Mr. Hicks wishes to challenge jurisdiction, he must file a proper motion. There is a process. There are rules. But Mr. Hicks refuses to follow that process. He does not want to submit paperwork. He does not want to argue within procedural boundaries. Instead, he repeatedly interrupts, speaking over the judge and attempting to control the direction of the hearing. The tension rises quickly. Every time the judge tries to clarify the court's position, Mr. Hicks cuts in. He demands answers on his terms. He questions the legitimacy of the court. He challenges the state's authority. Judge Perkins warns him that constant interruption will not be tolerated. The warning is calm, measured, and professional. But the interruptions continue. The judge explains that jurisdiction is clearly established under the laws of the state of Michigan and the court's governing rules. This is not a matter of personal belief. It is not optional. The court exists under statutory authority. The judge states plainly that the court has both subject matter jurisdiction and personal jurisdiction in this case. Mr. Hicks rejects that explanation outright. He insists that the judge prove jurisdiction on the spot. He demands documentation. He attempts to shift the burden onto the court to justify its own existence. Yet when the judge again instructs him to file a formal written motion if he wishes to challenge jurisdiction, Mr. Hicks refuses. He wants an immediate debate rather than following established legal procedure. As the exchange continues, the judge warns him about contempt of court. The warning is not dramatic. It is procedural. If a defendant refuses to follow courtroom rules, consequences can follow. But even that warning does not slow Mr. Hicks down. At one point, he escalates further. He references Title 18, Section 242, a federal statute concerning deprivation of rights under color of law. He suggests that the judge himself could be in violation. The implication is serious. Accusing a judge of criminal misconduct in open court is no small claim. Judge Perkins does not react emotionally. He does not raise his voice. Instead, he calmly acknowledges the statement and reminds Mr. Hicks that threats or accusations will not alter the court's authority. The courtroom remains controlled, but tense. Throughout the hearing, it becomes clear that this is not about the facts of the case for Mr. Hicks. It is about ideology. Sovereign citizen arguments often rely on the belief that laws apply only by consent, that courts operate as corporations, or that specific language can negate jurisdiction. The judge, however, stays grounded in established legal principles. Court rules govern the proceedings. Statutes define jurisdiction. Personal theories do not override them. Mr. Hicks continues to interrupt. He attempts to dictate the format of the hearing. He challenges terminology. He disputes the legitimacy of the charging documents. Each time, the judge brings the focus back to procedure. File a motion. Follow the rules. Present arguments properly. Eventually, the judge rules on the pending motions. The challenge to jurisdiction is denied. The motion to dismiss is denied. The court's authority is reaffirmed clearly and directly. The judge explains that the state's constitution, statutory framework, and court rules leave no ambiguity about jurisdiction. Still, the resistance continues. The judge then shifts the focus toward resolution. He offers options. Mr. Hicks may accept a plea agreement, resolving the matter without trial. Or he may proceed to a jury trial, where the facts will be presented and decided by a panel of citizens. One option is notably absent: a bench trial. Given the repeated accusations and conduct displayed during the hearing, the judge makes clear that a bench trial is not appropriate. The courtroom atmosphere remains strained. Every exchange feels like a tug of war between procedural law and personal belief. And then, something unexpected happens. When the case is called forward and preparations move toward continuing proceedings, it becomes clear that the officers involved in the matter are not present in court. Without the necessary witnesses, the prosecution cannot proceed. The judge reviews the situation and ultimately dismisses the case due to the failure of the officers to appear. Just like that, after all the arguments, interruptions, warnings, and accusations, the case is dismissed. For a brief moment, it seems the tension might finally settle. But Mr. Hicks is not finished. Immediately after the dismissal, he requests compensation. He asks the court to pay him fees and costs for defending himself. The request is bold. The judge responds quickly and firmly. There is no legal basis for such payment under these circumstances. The request is denied without hesitation. The hearing concludes not with shouting or drama, but with a simple reaffirmation of courtroom authority. Despite the ideological battle that unfolded, the structure of the legal system remained intact. The judge maintained control. Procedure guided every decision. Warnings were issued calmly. Motions were ruled on formally. And when circumstances required dismissal, it was done according to law, not ideology. What makes this exchange compelling is not just the confrontation itself, but what it represents. Sovereign citizen arguments often rely on the idea that laws are optional or that courts must prove authority upon demand. But courtrooms operate on established legal frameworks. Jurisdiction is not a debate determined by volume or persistence. It is defined by statute and constitution. Throughout the entire hearing, Judge Perkins demonstrates restraint. Even when faced with accusations of misconduct and references to federal criminal statutes, he remains steady. He does not engage in personal conflict. He does not escalate emotionally. He repeatedly directs Mr. Hicks back to process and procedure. Meanwhile, Mr. Hicks remains unwavering in his belief that the system lacks authority over him. The clash is not simply legal, it is philosophical. One side stands on structured legal doctrine. The other stands on personal interpretation. In the end, the dismissal of the case did not validate the jurisdictional arguments. It did not confirm the sovereign citizen claims. It occurred because required witnesses failed to appear. A procedural outcome, not an ideological victory. Yet the hearing serves as a powerful example of how courts respond to these types of challenges. The legal system does not dissolve under assertion. It does not collapse under accusation. It functions according to rules that apply uniformly, regardless of personal belief. This courtroom exchange captures that reality in real time, a persistent defendant challenging authority. A composed judge upholding procedure, repeated warnings about contempt, denied motions, serious accusations, and ultimately, a case dismissed for entirely procedural reasons. It is a reminder that in a courtroom, belief does not override law, and process remains the foundation of every ruling.